The delay here. As you know, we had some technical difficulties. I'll let you get sort of oriented to your packet a little bit there in front of you. Of course, it should be in the order for which you receive your documents. I did slip one item in there right before the legal report at the very end, and that's the voluntary disciplinary sanction matrix that, of course, Mr. Mansfeld and Ms. Tuck were exposed to a little bit over at the conference that they recently attended. And we'll get a little bit more update on that. But when we get to that update portion, I just wanted you to have access to that. So, but you should be able to sort of follow along, and it'll be a little bit tricky. So in between, as we go from item to item, I'll just sort of pause so you can sort of separate and find all the paperwork you need. So, but we'll get it all straightened out, and iPad should be in order come next meeting. So we'll get on board. But you guys, some of you like the paper anyway. I was just talking to Mr. Haston here, and I'm not much of a Kindle guy. You know, I didn't put money in stock. I was like, that thing will never work out. But apparently I was wrong and they were right. But I like the paper myself. So. All right, so I know. Yeah, she's just reminding me they're iPads, not Kindles. But yes, that's how far gone I am. All right, so if we would, Chairman, we'll call this meeting to order then.
All right, I'd like to call the June 20th meeting of the Tennessee Real Estate Appraiser Commission to order. We will start with the roll call.
Yes, sir, that'd be great. All right, Mr. Atwood, Brett Mansfield.
Present.
Francine Mello.
Present.
Sandra Tuck.
Here.
Nelson Pratt.
Present.
Dr. Mark Sunderman.
Present.
Will Haston.
Present.
And Eric Robinson. All right. We do have quorum. Chair, if I may just take a couple minutes, I'd like to introduce our new member, Dr. Sunderman. He comes to us from University of Tennessee. He knows Dr. Jane, and he's stepping in for him and filling that role now as our faculty representative. So he's sort of orientating himself to the process a little bit, and really he had a sort of a short runway, but had to dig in deep, and he's sort of reeling, but he's doing great, and we really appreciate his expertise. Yes, sir.
Clarification from University of Memphis.
What did I say? Did I say Tennessee?
University of Tennessee.
Woo! It's funny because my brain, I was seeing Memphis, but then my mouth said Tennessee, so I don't know what happened there. I need to get myself checked. Yeah, well, I appreciate that. Of course, some of our East Tennessee folks probably didn't mind hearing that. All right, good deal. Thank you, sir. Yeah, University of Memphis. So anyway, I don't want to offend Dr. Jane either. Well, welcome aboard. I'm glad you're here. All right. I think we can move to the agenda then. Do we have a motion in that regard?
So moved. Accept the agenda.
All right. So we got a motion from Dr. Atwood and a second from Ms. Tuck. So
I'm graduated to doctor now.
Yeah. Did I say Dr. Atwood? Boy, I'm gonna have to go sideline. What is going on?
I get called Dr. Atwood a lot.
I've got
not.
All right,
okay. It's been a
Mr.
rough morning.
Atwood. I was trying to give you an honorary degree.
Well, hey, if it works, I'll take it.
Yeah. All right. So all in favor, please say aye.
Aye.
Any opposed? All right. Hearing none, we have agenda then. I think we're ready for the March minutes.
Motion to accept the March minutes.
Motion from Mr. Atwood, second from Mr. Pratt. All in favor?
Aye.
Any opposed? All right, hearing none, then the March minutes are approved. I think we're ready for the experience interviews. I'll let you sort of find your place there. I'm gonna go ahead and read what we have, and then of course I'll pause for where there's blanks for any updates from the reviewers. We've got James Dalton, Mr. Atwood. He looked at James Dalton and Daniel Owens. Both were a yes. Mr. William Haston looked at Jennifer Trosper. That was a yes. Mr. Brett Mansfield looked at Kimberly Prescott, and we just need a recommendation on that.
Yes as well.
All right, yes for Kimberly Prescott. And then Mr. Pratt looked at Alexander Tipton and Ryan Foster. Yeses on both of those. And Miss Tuck looked at Gerald Terry. We have a yes. And for Jessica McLennan? Okay. Yes for her as well. Okay. Do we have anyone that we want to add to that group that maybe were not included? All in favor of those recommendations, or excuse me, do we have a motion for those that would be in favor of those recommendations?
So moved.
All right. Do we have a second?
Second.
All in favor, please say aye.
Aye.
Or any opposed? All right, hearing none, then those experience interviews were approved. And thank you for your effort on that regard. I always pause every once in a while, and I do want to reflect periodically on the effort that goes into that. That's a big lift, takes a lot of time. And I don't know that people really, I don't know that I would have, just from the outside looking in, would have fully appreciated the effort that goes into that. Those are very technical reports, and these are folks entering into the industry at various levels. And so I know you leverage your experience and your expertise in that regard for the sake of the public. So thank you for your efforts. All right. I think we're ready then for application review. There's should be 7 pages in front of you. I gave you sort of a quick outline, sort of what I'm just going to do a brief summary of what the issue is there, what the TCA code we're looking at that's in view, and then allow the board to discuss. The controlling person for the initial AMC application indicated no in 2 places. To the following question, the question is this: it's as articulated on the app. Have you ever been convicted of, pled guilty, or pled no contest to any criminal offense? It didn't specify. It just said any criminal offense. This same question was on the online application and a paper affidavit. And I want to reiterate, the issue here was not defense itself, as it would not meet the high standard of the Fresh Start Act and would have been approved. The issue is the misrepresentation itself, and especially as it pertains to the affidavit. So that's an item that we were somewhat concerned of, especially in light of TCA 6239.410B, which states the designated controlling person pursuant to subsection A shall, 2, be of good moral character as determined by the commission, and 3, submit to a background investigation as determined by the commission. It was not until the background report came back with an indication that the acknowledgement and explanation was provided. So that timing was important as well. So just at this point, initial thoughts, and then from there we can springboard into that conversation.
So the only issue for clarification is inconsistency in the way the application was filled out.
It was the misrepresentation itself to the question, are there any criminal offenses? And him answering no twice, not once, but twice, and once on affidavit. That was the issue for, to be discussed.
And so this is for an appraisal management company, correct? And so this is the representative of that.
This would be the controlling person. That's correct.
We're looking at to either accept this or deny their application.
That's correct. Right.
So the offense the party was guilty of occurred when they were 18. They're 38. Since then.
The real question is, there was an intent to mark those items as no. It wasn't an accident. It is really the main issue is determining if that was an intentional omission of that, or is there? Can I ask if there's any legal precedent? Is there any anything from this board or previous boards that would be any precedent of something like that?
I don't know if there's specific legal precedent for this board or other particular boards, but it is the determination for you to determine whether you believe that this misrepresentation, how much weight it holds, and whether you would like that to apply to their application or not. So we discussed this prior to, and we thought it was important to come before the board since they did make this decision, not twice, essentially. And so it is your decision to make at this time. These are really, kind of on a case-by-case basis, so I don't think you're really held to one particular decision.
Could you, do we have any sort of idea of what other states they're practicing in? Or, have they been approved in other states? Do we know how that went by chance?
I've got, one of the perks of not having the iPad, but having my laptop in front of me, I can look at some of that and dive into the registry and see if there's something there. That would, of course, be helpful. So if you want to continue to, what was that? What was it? Was it Walters that said, I'll give you a topic to talk amongst yourselves? You know what I mean? So I'll look in here and see if I can find something.
And one other question. Could y'all explain, so what was the two-step process again to apply for the AMC?
Go ahead. I'm sorry.
I was wanting to know the two-step process to apply for the AMC. Apparently y'all have alluded or said that he answered no twice, and so
there's a affidavit of controlling person. It's basically an affidavit along with some other documents that they attach to their online application. And so, there's the online application where he's going through internally and answering those questions, drop downs. And so typically I give someone the benefit of the doubt because those drop downs can toggle, right? And usually somebody comes back with an explanation. Oh, I'm sorry, that was an accident. But then the handwritten one is he had to physically go in there and check no on that one as well. And, given his explanation, I was a school kid too when been in a couple, scraps, and I remember those, so it was a long time ago as well. It wasn't yesterday, but in high school, you still, I remember them.
Right. So we've got the application, right, with the question, and we've got the question that says no. And then we've got the controlling affidavit here, where we've got the individual has written their name, filled it out by hand, and they've signed it. And I think the affidavit is, important to read because you're certifying that the records and, accepting the responsibility and stating that the information is correct. And so that is those are the two different things that we're providing for you.
If we deny the application, will they have the opportunity to reapply?
At this point, they would probably have to submit a different controlling person. Will, thanks for doing the legwork too, Will. He looked at the AMC or the registry, and he's licensed, or this one is licensed in 8 states. That makes it more difficult, doesn't it? Right. And to since I just promoted Dr. Atwood over there, Dr. Atwood's correct. We didn't have any heartburn over his explanation or even the charge. It was just, at 38 to be marking, in 2 different places. That's problematic. So we just had to discuss it.
Yeah, I think to everyone's point, the actual incident, and the explanation of that, I don't think is of any real concern. It's just if you're going to sign the affidavit intentionally and not bring that to light until which time the background check comes out is what's concerning to me. There would be no divulging that information without the background checking that. So to me, that's a little concerning that there was a knowingly false document signed there.
Do we know if he's had any issues in those other 8 states?
There are no disciplinary action listed on the AMC registry for that AMC.
Thank you, Will.
And is he also the controlling person at each of those states as well on those applications?
That's not listed on the registry. I can't tell that.
Typical for an AMC to have different controlling persons in multiple states? Is that a typical or atypical thing? Does anyone know that?
Without them reporting that data, it'd be hard to trace. Yeah.
Would you like to put a motion on the floor? Or?
What? Just so I'm clear, if you were to make a motion about denying the application, then this firm would have the opportunity to reapply with a different managing member at some point in the future. Is that the way I understand that correctly?
That is correct.
Could it be deferred until we have a chance to speak with Eric Robinson, who might know the answer about the controlling partners and everything?
I guess my question would be the whether to know if there are different controlling persons for AMCs. So, I mean, you could wait for that information. I do want to say, if we were to deny the application, it does say the designated controlling person shall have never had a license or certificate to act as an appraiser, refused, denied, canceled, revoked, or surrendered in lieu of a pending revocation in any state. So that, to me, so there may be some ramifications for denying the particular application related to the controlling person. So if we wanted to wait to make that decision, it's possible. But again, that would just be delaying the application to another meeting. But it just is up to you to make the decision, whatever decision you would like to make. I will say I'm not going to make a particular recommendation to the board, but I do believe that making misrepresentations on your application is a serious issue, even if it was something that occurred when you were younger, unless that has been, is something that's considered to be criminally, like judicial diversion, or something that was sealed or expunged or something of that matter. That is something, like Mr. Kopchak was saying before, it should be disclosed. So that is something that you should consider to be in your decision when you make that, which is one of the reasons that we did bring it to you today. So that it is something, I think, serious to make a misrepresentation on your application, because but for us having the background check that's required, the application would move forward, because if you say yes on your application, you cannot be the controlling person, and therefore the AMC cannot be approved. So the implications of that no are, significant.
Could you break down the ramifications again from us as a board if we were to deny what you had made?
Right. So if you were to make the to deny the application, I believe in this circumstance, what would be required is that this particular appraisal management company would likely need a different controlling person to be submitted for the application. I'm not sure how that works regarding appraisal management companies, if that can change depending on the jurisdiction. But as it is now, based on the information that we have, if it was denied, it would state that any person that would, if their license has been denied, related to it. But it does state here, anyone who's had their license or certificate denied as an appraiser cannot be owned or in part, but we're not denying their license as an appraiser here. It would be part of the appraisal management company. So I think that would be different. So I believe in this circumstance, it would probably be that they could possibly resubmit an application.
But you stated that if he would have, or he or she, whoever marked yes, I thought the Fresh Start Act would have overrid that, right? Overrode that.
So if they checked yes, then we would go through the Fresh Start Act, right? And the commission would have a discussion to make a determination whether the offense directly related to the profession. And you would after we have that discussion, you would make a determination. And if you said yes, it does directly relate, then we would deny and the application would be denied. If you said no, then it would proceed, the application would proceed, but we did not get that far.
And really the only negative consequence if we were to wait for Mr. Robinson to weigh in the next meeting is it just is delayed until the next meeting, correct?
Correct.
I think it's a good idea to probably have Eric weigh in, but I'm willing to vote today if we feel so moved.
So regarding waiting, does that appear to be sort of where the board is going? Then we can defer to the next meeting if I could see the wisdom in having, Mr. Robinson present in that regard. To your point, I think that, it's because the only consequence here would be that another controlling person on an application. However, what are those consequences to the other 8, places that controlling person is active? I imagine he would be able to speak better to that than we could, since obviously our jurisdiction is Tennessee, so that's our focus. So the practical implications of that may be instructive or helpful. And so if that's worth waiting, then I think absolutely we can. You've got your read up, everyone's briefed, and is prime now for that to pick off and have that.
But no con.
I believe it was a misdemeanor.
If he had to do all of that, it would be a felony or a misdemeanor.
That's really more all encompassing rather than restrictive. That's saying, do you have a charge that on your record? Do you have a criminal offense? In essence.
Do we have any thing in the law codes anywhere or in the bylaws or whatever that specifically states that if they misrepresent on an application, there is a certain disciplinary action that goes forward, or is that even discussed in the regulations?
I know that it is for sure in the appraiser statutes, but let me double check for AMCs really quickly.
response to Sandra's question, in his first line, he said that he had been arrested for assault, battery, criminal trespassing, and mob action. So he said he had been arrested, and then later he said he was sentenced too. So I would assume that that was all tied together.
I just wondered if you, like, sometimes they consider somebody.
Yeah, a jail tour is a conviction. You know, that's using more passive language and sort of distance, but that's a conviction. You know, you got sentenced, and that's why there's an indication on the background check. Right.
So under the AMC statute, it does say procuring a license by fraud, misrepresentation, or deceit.
What are the repercussions of having done so?
So it's under, the regular disciplinary structure. So it can range anywhere from civil penalty all the way up to revocation. But since they do not have a license at this point, it does not fall into that category.
Just to clarify a couple points before we kind of make a decision, since this is not an appraisal license, if in the event we were to vote this time or the next meeting to not accept that, that would not, it's our understanding that would not preclude them from reapplying with a different controlling member. That's the way we understand that portion of it, correct?
Yes.
Okay. Okay. And then just for discussion, I mean, having, the AMC person on the board having comment seems to carry some weight in this, particularly does this have any impact on their ability to retain licensure in other states, correct? I mean, that seems as if we might want to wait on his opinion. Does anybody have any thoughts on that?
Do we need to vote on that if that's?
No, you can defer. That's fine. Yeah. But maybe we take a vote just so we get the will of the commission, so we know that that's what we're doing. Maybe we just do that. If you want to lead that, that'd be fine.
Sure. Does anybody want to make a motion to defer to the next meeting?
I'll make a motion to defer to the next meeting.
Got a motion on the floor. A second.
I'll second.
Motion and a second. All those in favor say aye.
Aye.
Any opposed? All right. Motion carries. We'll re-examine this at our next meeting.
That's good discussion. Thank you for sort of ferreting that out a little bit. We'll be ready next time, especially with Mr. Robinson here. It's a good deal. Thank you. All right. We are ready for the education report.
Yes, that's me.
Sure, you can jump on in there.
I sent the information you have in front of you does not have my comments. I sent my comments on Sunday, so you don't have my recommendations. I had recommended approval on the items that are blank. I had some questions on a couple of them, and I talked to Will and Glenn prior to the meeting. My concerns have been, and these are issues that may need to be addressed later, but the application asks for a lot of information, and there were several of the applications that did not have everything there. One of the issues, it was usually based upon policies, like how they're handling attendance, record keeping, refunds, and things like this. And several of the applications did not talk about those things directly. And I didn't know whether we required everything to be covered on the application as laid out. So I wasn't sure about that, and evidently we have a little bit of leeway on those issues. Also, in the future, when I get the material, I intend to go through the stuff, and then I can contact Will and we can go back and forth. And if we need more clarification, it's easier to get that information in advance rather than at this point saying we deny it and have them wait 4 months or whatever for us to look at it again. The other question I had is a couple of the applications actually dealt with education that was based on report writing for Georgia or dealing with issues dealing with legal issues in another state. And I was questioning, is that something we should be concerned about? And evidently, that's not a major issue as long as it's dealing with an appraisal topic. It's not like we're talking about a real estate issue or something uncontrolled. So I see no problems with any of the courses that do not have a blank. I looked at the items that are marked approval on the sheet were ones that Dr. Jane had gone through in advance. I glanced at a few of those to get some idea how he was going through the process, so I'd have some idea what to do, and I saw no problems with those, but I did not go through everyone that he had marked approval. So, questions?
Yeah, I'm a little confused. You're saying you did approve the ones that have a blank,
Yes.
so they're all approved now.
Yes, this was sent to me earlier. I sent to Glenn and Will my copy, which has the approval mark, but obviously they got them Sunday, and they were not forwarded on to you.
He was sort of drinking through a fire hose. We were doing orientation and trying to do course reviews, and he had to look at all the rules as well for content. And he did a fantastic job, given with all of his other responsibilities at the University of Memphis. Right. So we appreciate that. Thank you.
He is a doctor.
Yes. I hope so.
All right, we've heard the education report. Do we have a motion?
Motion to accept.
We've got a motion and a second on the floor. All those in favor say aye.
Aye.
Any opposed? All right, the education report motion carries.
All right. Thank you, board. Appreciate that. All right. The director's report then. We've got the budget. Let me grab it. Right behind the budget, you'll have the disciplinary action matrix from the Aero conference when we get to that discussion with our two members and our representatives for this board. For the, I'm so used to iPad, I keep wanting to take my fingers to enlarge the screen. I really can't do that. All right, so let me pull up my notes as well. I didn't see anything outside the ordinary. Primarily, you'll look at the other line. We covered the months through December last meeting. We only have 4 months of record on this budget, January through April. The large expenditures listed under other for February and March are the appraisal subcommittee, national registry fees, basically the panel reporting that's due this time of year. That's pretty common. And you'll see revenue spikes that coincide as well. So it's basically us collecting those fees and then passing it on to the registry, per statute. So that's what you're seeing there. As far as trending year end over end, I didn't see anything that just jumped out at me. And it's for informational purposes only. For our new member, if you'll indulge me just for a second, I'll kind of go over a couple of those line items, what those entail. But it's basically a P&L chart, Dr. Sunderman. Obviously you noticed that, but revenues on top, the profits, if you will, and then the losses or expenses down below. Administrative cost backs are basically anything on the ledger that mirrors Edison. Edison, does a lot of things. It handles travel, expenditures, refunds, but it's also sort of the ledger as well for different account line items. And so those are counted there. But then administrative costbacks are those things that don't fit nice and neat into Edison, but are sort of they mirror Edison. For example, you would have shared expenses with rent or phone or technical services. If they're doing something for all of the boards, we get a share of that proportionate to our licensee count and also our complaints as well. So I mean, our portion is going to be a little bit smaller, and plus you also have some admin staffing that's not necessarily particular to our board, but then we share part of that. We have some admin business analysts, auditors that work for all our regulatory boards. So we're getting a section of that cost, and that's happening at administrative cost backs. And I get an expenditures sheet that comes out every single month. And so what I do is just look at those charges and make sure that they're consistent with months prior. And so far, what I can tell, it seems to be on course. I didn't see anything just outside of the ordinary there. Of course, I'll entertain any questions as pertain to that. Technology, self-explanatory, salary benefits. Other can encompass some of that, but it can also encompass some admin cost backs, such as what we described earlier, our utility bills that we share. We don't just put our board in one corner and then we're responsible for that one light bulb. We have to bill it across the board and then proportional then apply it proportional. Centralized complaints is basically in our call center, customer service center. If you call to give a complaint or if you're asking questions about licensure, that's our call center. So they charge us as well proportionally to the use and the service they provide. That's pretty much the extent of it. We're tracking in surplus. We do have a sunset hearing coming up soon. I'll have more information from that, but your newly minted chair here will be going up the hill and entertaining questions they may have at government ops. So he's gonna do great. I'm sure. I'll just have to try to, that's. And I said it'll be good time. So now there's. The scrutiny there won't be maybe necessarily as intense as perhaps some other boards because it's federally regulated. But certainly we're going to be prepared and, answer whatever questions our legislators have for us.
All right. Thank you. Does anybody have any questions on the director's report discussion?
Just curiosity, is March typically a month that we see a lot of licensees apply to become appraisers? I mean, that just seems
that's the panel reporting that you're seeing there, because the AMCs, they report how many appraisers are in a covered transaction, and then there's a $25 fee for each one of those appraisers that we collect for ASC and then remit that back to them. And they're reporting for the calendar year, January through December, and that reporting period begins the next year from January to the end of March. And so that's why that big spike in increase that you're seeing there, March, it's like right before the door closes on the expiration. You imagine that's human nature. We see that in all licensing. Folks are piling in, getting those reports in, and then we're reporting that to the ASC. And as a result of that, that's why you're also seeing that same expenditure, those big expenditures in other, because those are ASC or expenditures going back to them.
Any other questions? We'll need a motion to approve the director's report.
I don't think so. I don't think there's any actionable items, so this one will be informational purposes only. But okay. Yeah, thank you for entertaining that. I think we're ready for Aero Spring Conference update.
All right. I will lead this off. Commissioner Tuck and Taylor were there present as well, so I'll let them jump in at any time. This was the first time that I have attended Aero, and I found it very rewarding. And so I would encourage any new commission members who have the opportunity to go in the fall or in the spring and in the future to take that opportunity and go. But I'll kind of hit some of the highlights that were discussed. Two big issues that were hot button topics, so to speak, were appraisal bias and PREA and the implementation of that. Jim Park with the appraisal subcommittee kind of led us off in the first session, and he talked about how the states are about to go through the compliance review process, and this happens every 2 years, and then kind of reiterated that the appraisal subcommittee was focused on appraisal bias. He also wanted states to take a look at, and we've done this and consider it, but the barriers to entry with our laws and regulations, and if there is anything that is more stringent than the federal regulations, then we need to have a pretty good reason. Next, Dave Bunton with the Appraisal Foundation spoke, and he provided some, I thought, two very good items. One was the previously mentioned disciplinary matrix, and this is just that. It gives us an idea for first offenses with different violations and where we could kind of head, basically to help us make decisions. And I don't think we've had anything like that in the past. And so I would encourage everybody to take a look at that, and the implementation of that. I guess we can discuss that, but it was a good tool to have. Another very helpful item that he discussed is that the Appraisal Foundation actually puts out education classes for offenses, and these are all 4-hour classes, and they are written by the Appraisal Foundation, and they utilize a third-party provider, but they are non-credited classes, so you don't get credit for them, but they're all 4-hour classes. There's a lot of times when we're dealing with disciplinary issues that maybe we'll find a class that kind of fits, but these were a little bit more specific, and I'll just kind of run through the classes real quick. There was just 5 or 6 of them. Appraiser self-protection, documentation and record keeping, report certifications, residential report writing versus form filling, scope of work, appraisals and inspections, assignment conditions, elements and results, missing explanations, sales comparison approach, reconciliation, and then ethics, competency, and negligence. And so these are all on the Appraisal Foundation's website. And so something that we could look at in terms of recommending education, maybe a little bit more specific to the violation that we've found there. And then Brett Sweeney with the Appraisal Qualifications Board spoke in January 1st of 2026, they are going to require a 7-hour fair housing class for all appraisers. And so that is coming at us in 2026. So the first time it's going to be a 7-hour class and a 1-hour exam, and then there will be a 4-hour update that coincides with your USPAP update every 2 years. He talked a lot about PAREA, and that is now since Arrow, it has the first PAREA offering has been approved through the Appraisal Institute. I believe that McKissick is close to getting theirs through and completed. As a state, we have already approved it if the AQB approves it. So that is now an offering in our state, PAREA. They showed us a lot of information about it, from videos to different things. And if you're not familiar with it, I would highly encourage you to do a little research and watch some videos. It's not an easy thing for anybody to go through. It's going to be a difficult process, but some of the things that they can do were I found, I think it's going to be beneficial in the training and getting new people. Yeah, absolutely.
Commissioner Tuck, will you speak into the microphone?
Okay, before I was at this conference, I was a little hesitant about PAREA, but after I went, I was a proponent for it because these people are going to have completed all of their training, their required courses, before they even go into the PAREA. And then they're going to do a computer module where they're going to have a mentor, and these mentors are actually paid through AI or whoever they do it. So these are just not volunteers. These are people that are trained and going to help these people. And I was pretty impressed with the training that the new appraisers are going to receive.
Yeah, and they showed us some examples, and it is, everybody's seen the walkthroughs of houses where you can kind of go from room to room. So it's similar to that, but they even show you how to measure a house, and so they'll give these the prospective applicants a property, and they can walk through it and do an appraisal, and then they can switch it and make the house a lot nicer, or put a cell phone tower in the backyard, or what it's things that probably they're not going to see on a day-to-day basis, just training in a specific area doing certain types of property. And so similar to what Commissioner Tuck said, I was pretty impressed with what they provided. So, and then Michelle Bradley with the Appraisal Standards Board spoke briefly. The 2024 use PAP was approved. Really, the major change in the 2024 use PAP is that use PAP is always stated that as appraisers we can't be biased. We have to be impartial, but in the 2024 version, it explicitly states about appraisal bias and lists some federal anti-discrimination laws, and so that's going to be in there. She also stated that the 2024 version of USPAP will not have an end date, so it's going to be active, I guess, until they decide. So maybe not a every 2-year update. And then a couple other things. They had mentioned about potentially having this has been a discussion in the past, but some sort of education clearinghouse. So if we would have access as a state to see that, hey, this class has gone through, and Alabama, Mississippi, and Georgia have approved it. How does that help us make a decision or not? And so they felt that this was probably going to be something that's going to happen sooner rather than later. And then we looked at Texas and kind of how they're dealing with some fair housing issues, and so some things that we can maybe think about. But again, overall, it was a good experience, and would highly encourage anybody to take that opportunity. Taylor, did you have anything that you wanted to add or you thought?
Yeah, I would definitely second that. It's a great experience to go to if you haven't been through it, and it's very. This I thought was probably the most. I've been to one other one. This one was very informational and very interesting. I thought I liked this one a lot, and I would say for Priya also, they did offer to have someone come in and give a presentation to different boards and commissions if that's something people would be interested in, which I think is a great idea if anybody wants more information about it.
Another thing that came out was that they had the question, is Tennessee going to be able to accept approved PIREA as certificates, or will that require legislative change into how we license or certified people?
We have accepted it, and we've posted on our website to that effect as well with instructions for that. So we're all, but we won't see one probably for another year and a half, 2 years till they complete the program. But yeah, we're already anticipating us bracing for that as well.
And they, in terms of getting ready, that January 1st, 2026 date for the mandatory class, they're giving that amount of time so states can implement that into our laws. And so I don't know if that's something that and because that's such a there's little information but more coming as we go, because a lot of states they're trying to figure it out themselves as well, and so they're trying to brace for that. A lot of folks think that because AQB's approved it, that it's just hitting a light switch. The good news is for Tennessee applicants, if they're listening, that's approved, and we're going to accept PIREA, and so that's the good news now. So they can jump on that and start working on that, and then a year and a half from now, all of that will be ironed out. But the place for that information, if they haven't signed up for Notify, would be the place to do that, because that's where that information is going to come. Just notify.tn.gov, but also on our website. We're going to lead front and center on our website. I don't want folks buried in announcements or FAQ page four deep. I'm going to put the front and center. So if they go to our website at all, they're going to see that on the front of our website with that new that current information. So I would just direct folks there. So what's the date of our next meeting? Because I think the fall era is in October.
You were reading my mind, and I just wrote down here 9/12, and it's a good thing I had our computer in front of us. But I was thinking, yeah, we're gonna. I mean, we could turn that ship pretty tight. But maybe when we get to new business, if the chair would entertain that, if we could just bring, since it's not on the agenda and we didn't vote to add it. We could just add that. But the dates for the annual meeting for Arrow is October 6th through 8th in Salt Lake City. So maybe as you're looking through the legal report, if some of you could look at your calendars and see if you'd be willing and able to go, then we could have that when we get to new business. Chair, if you wouldn't mind introducing it.
Absolutely.
Could you provide some additional information at some point about this conference? Because
Yes, sir.
obviously, as a new member of the board, I have no idea
Sure.
what you're talking about.
Yeah, sure. Actually, I just sent you all an email with the matrix, and then on the heels of that, I'll just of course I got a blind copy. Otherwise, it's a meeting. But I'll send you the link to their page as
you.
we're yeah.
All right. So moving on now to legal.
Okay. Good morning. Hope you guys are all doing well. Before I get into the legal report, are there any that you would like to discuss first or any questions?
We have in the past grouped the dismissals together, and those were items 1 through 5 that council had recommended to dismiss. Are there any of those that, I guess first, has everybody had the opportunity to read through it? And second, are there any of those that we would like to pull out separate or vote on them together, or any recommendation? Okay.
I'll make a motion that we accept council's recommendation to dismiss on numbers 1 through 5.
All right. Do you need to read those in before we vote?
I'll go ahead and do that.
You need a second.
Oh, yeah.
Second.
I'll go ahead and read those in now. Number 1 is 2023002881. Then 2023014341. 2023018341. 2023021741. And 2023006801.
All right. We've got a motion on the floor in a second. All those in favor say aye.
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 Any opposed? Okay. The motion carries to dismiss items 1 through 5.
Okay, moving on to number 6, which is 2022030501. I'll just give a brief summary and then we can get into discussion on that. Complainant alleges that they state that respondent conducted an appraisal of their home, and they allege that they were unaware that respondent was coming to the home to perform the appraisal as they were hired by opposing counsel in their divorce proceedings. Complainant alleges that the value respondent found was not based on accurate information. They specifically alleged respondent used inappropriate comparables and listed incorrect square footage for the home in their report. Additionally, complainant alleges respondent is working with the opposing counsel in their divorce to give an inaccurate appraisal. Respondent denies these allegations. They state that they personally measured the home on May 20th, 2022 with both a tape measure and a laser measuring tool. Respondent states complainant is comparing their appraisal to a different appraisal that was performed 8 months prior, which is not relevant. Respondent additionally states that they did not review the prior appraisal and do not review other appraisals' work as their reports are based on their own findings. Respondent states their comparables used were respectively close to the subject property and within the marketing area, and they deny being bribed or working in cahoots with the opposing counsel. An expert review was completed. The expert found that overall the report was credible and the submitted materials appeared to support the opinion market value. They did find that the neighborhood statements were very canned and found this to violate USPAP standards 11C, 12E, 21B, and 22A. Based on the minimal findings and that they had no history, I was just recommending a letter of instructions based on those violations found.
Discussion?
I do not think canned statements are a violation of USPAP. I don't like them. I teach against them, but I don't see how they're a violation. Someone else can address that.
Could y'all refresh me on the letter of instruction? What is that?
Yeah. So letter of instruction is not formal discipline and it's not reported to the National Registry. It's just kind of basically letting them know, hey, we looked at this. These are some possible issues. And then it just kind of lists the rules and gives them the information. So it's not formal discipline.
I think I read in here that the expert found that the report appeared to be overall credible and that the submitted materials to support the opinion of value. So I would recommend that we dismiss it. I feel like, and it may be that somebody is upset that it's a divorce appraisal.
Yeah, I definitely feel that way too, and that's why I didn't want to go with formal discipline. I just wanted to put on there it's just kind of a way to let them know, like, the expert reviewed this is kind of what they found, but I'm open to either way. Just was putting the option out there as a way to let them know.
Commissioner Tuck, is that put that in the form of a motion?
I would recommend that it be dismissed.
Second.
Got a motion and a second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Okay, motion carries.
Okay, moving on to number 7, which is 2023004271. In this, complainant is alleging respondent did not come back to their home to take the required repair pictures, and that complainant instructed them to take pictures of the subject property and send them to them and to not let anyone know. Complainant alleges respondent is holding up their closing because they're failing to do their work. Respondent states that they were initially hired to perform an appraisal on complainant's property by an affiliate company. They state they turned in their initial report subject to a installation of a handrail on the stairs leading to the home's basement. Respondent states following their submission, they were asked a few weeks later to complete the final report. They said that they tried to schedule a time to come back to the home and take a picture of the installation of the handrail. They state, however, complainant was going out of town and was refusing to set up a time that worked for both of them. They allege that complainant was being abrasive and uncooperative. Respondent states additionally at that time, they were receiving a lot of pressure from their client to turn in their report, and complainant had asked if they could just send a picture of the installed handrail. Respondent states they initially explained that they have to see it in person. They cannot accept a photo. Respondent states, however, after receiving this pressure from their client and the complainant being unwilling to work with them, they did eventually accept the photo from the complainant and use that to complete their report. They say they apologize for this and they would not do this going forward. I was recommending a letter of warning.
Say something?
Yes.
Okay, this was opened on February the 13th of 23. On March the 1st of 23, all the Fannie Mae rules changed. So it said the appraiser can complete the completion report of Form 10-1004D based on an on-site visual inspection or alternative methods such as virtual inspections, digital photos, site videos, or other technological solutions. And I have the Fannie Mae selling guide reference to that. So 15 or 17 days after this, it was legal to do a photo.
Is this an FHA appraisal or a conventional?
It doesn't tell us.
Let me look in the folder. This was prior to the rule happening, though, so technically it is a violation, but that's kind of at your discretion.
Do you know?
I'm pulling up the report. I had to find the name for it on here. It's FHA.
I don't know.
Is there a certification on the 1004D, or that's just really an appendage to the report, right?
Say that it's been completed. In other words, any repairs.
And usually for FHA, you state that it meets HUD's requirements, HUD's minimum property and safety requirements. And I'm not sure, unlike Sandra, if they changed that for FHA. I know they didn't change it for VA, but sometimes lenders will let VA repairs be taken by the property owner or the borrower. So it's kind of a gray area.
I would recommend that.
Okay, we've got a motion on the floor for dismissal.
Second.
Got a motion and a second. Any further discussion? All those in favor say aye.
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 Any opposed? Okay, motion carries. Moving on.
Okay. Number 8, 2023008501. Complainant alleges when respondent was performing their appraisal, they failed to include the 2 bonus rooms that would be in the upstairs of the house in their report. Complainant alleges accordingly respondent's report was inaccurate and in violation of USPAP. Respondent states they initially did not include the upstairs area in the GLA calculation because they were told the area was not going to be finished and to proceed without it. Following turning in their report, respondent was informed by the bank that they now needed to include the upstairs in the calculation and were instructed to redo their report. Respondent says this changed the square footage and they updated their comparables and returned the report into the bank. An expert review was conducted. The expert found the following violations. In the neighborhood section, they found there is no support for the one-unit housing trends reported in the neighborhood section of the appraisal. They found there is no summary of the analysis supporting the stable values indication, the shortage in demand supply indication, and the marketing times under 3 months indication. Under the marketing conditions, the expert found the appraiser states housing trends, exposure times, etc. are based on data available as the effective date of the report. However, the data available is not summarized in the appraisal as required by USPAP. Under the site/highest and best use section, they found there is no summary of the analysis undertaken in support of the highest and best use conclusion. They found the appraiser states in the site section that the subject's current use is legally permissible, physically possible, financially feasible, and yields maximum profitability. However, there is no summary of the analysis undertaken in support of this conclusion as required by USPAP. Under the sales comparison approach, they found that none of the comparable sales are located within the same city as the subject property. The sales were located all multiple miles away from the subject. They found there's no summary of any location analysis undertaken addressing the need or lack thereof for location adjustments. They also found there is no site size adjustments having been applied, and there's no summary of analysis in support of the lack of site area adjustments in violation of USPAP. They found there's no analysis of the subject's prior sale in violation of USPAP. They found the reconciliation states the cost approach is considered a supportive value. However, the value per the cost approach does not support the value opinion. The value opinion of the cost approach is not reconciled to the value of the sales comparison approach or the value of the opinion in violation of USPAP. Based on the expert reviewer's findings, I was recommending the commission authorize a consent order requiring continuing education to be completed within 180 days of the execution of the consent order, and for these classes to be completed in addition to the continuing education requirements for the license renewal. I was also recommending the commission discuss and decide the appropriate continuing education classes to include.
Okay, thank you. Any discussion?
Yes, I have a question. Prior history.
Yes.
There's a letter of caution for failure to timely complete continuing education requirements. Do we know what those education requirements were at that time?
Let me go ahead and pull up their previous folder.
Yeah, thank you.
It was their general classes that they didn't complete, but I'll look and see if I have specific, like what ones they were missing when we issued that.
There must have been a previous complaint prior to 2021. In order for them to be required to take education, there must have been a.
Sorry, no, that was their license required continuing education
their
that
license
they didn't complete.
required.
Yes,
then
yes.
That's fine. Thank you.
Yeah, sorry, I thought you were looking for clarification
They've
of what
not
classes
had
they
a
were
previous
missing.
complaint
Correct.
that required them to take
Correct.
additional education.
Yes, correct.
Thank you.
Yes, I'm wondering why the complainant filed a complaint. I mean, the person was told, it says in here that the 2 bonus rooms weren't going to be finished, so they didn't include it. And then they were told by the bank to go back and redo it because they were going to be finished. So they did it. So what really did the respondent, complaint?
I guess it comes down to what they said versus what the respondent is saying. So the complainant just feels that the respondent did it incorrectly to begin with, and the respondent saying they did that because they were instructed to by the bank. So it's kind of just competing stories of what led to it.
But in the end, it got done correctly.
According to the respondent, correct.
Yeah.
Yes.
However, the review turned up multiple USPAP violations. Fortunately, happens a lot in that you weren't necessarily guilty of what the complaint is, but you're guilty of a whole lot more.
I mean, based on these items, to me, legal's recommendation of continuing education would be necessary. Is there any conversation about what order or the number of classes that might be reasonable based upon, these specific violations?
I would recommend, I hadn't made a motion yet, but just for discussion, that we consider education in the form of sales comparison courses and market analysis, highest and best use course. There'd be two of them. So the sales comparison, just to give you something to think about, the sales comparison course is 30 hours. I'm sorry, is 4 days. What is that? That's 30. Is that 30 hours? That's 30 hours. And the highest and best use market analysis is 15 hours. That's what I would think about recommending, those two.
Yeah, I agree with Dr. Atwood.
From the University of Tennessee.
That's right. So I'll put it in the form of a motion that we require 30 hours of sales comparison and 15 hours of market analysis, highest and best use.
And is this in addition to CE?
In addition to CE, yes.
Okay. We've got a motion on the floor.
Second.
Got a motion and a second. Any further?
Yeah, what do you want to do with that 180 days?
That's fine.
Okay.
Well, it's hard to, they can get that in. I know of a particular education provider and instructor that will be teaching that in just a couple of months.
They would be able to take that online, though, as well, correct?
They can take it online.
Any further discussion? All right, ready for a vote? All those in favor?
Aye.
Any opposed? Okay, the motion carries. Moving on, item 9.
Okay, and number 9 is 2023024291. And is there any discussions or questions about that one?
A whole lot.
I guess I'll start. I've got a question or two.
Yeah.
So I guess the first is, does this fall within our jurisdiction?
Yes.
It does.
Yes.
So in terms of violating USPAP or?
So USPAP has an ethics requirement. It's also professionalism that the board can hold appraisers to. And also this happened while he was conducting an appraisal. Or while they were conducting an appraisal, sorry.
The ethics rule states that you can't engage in criminal activity.
And this would be, if the homeowners wanted to pursue this, they could.
But they haven't been found guilty of that in a court of law.
That's correct.
So they're innocent until proven guilty. We're just asking. We're puzzled.
Yeah.
This is a puzzle.
There is video tape of the
that.
occurrence, so, but yes.
That's what the law says.
Yes. I have not. They sent the link.
I guess I'll rephrase. Was that submitted with the
Yes.
complaint?
Yes, it was.
Okay. Thank you.
So basically, they were accused of touching.
Yes, in other words.
Go ahead.
I don't know. Go ahead.
Do you know if they're filing any criminal or?
I do not. They did not include that within their complaint.
And just so I know, the 6-month recommendation, is that from any sort of past precedents?
No, that's just something that the three of us discussed. We weren't really just, we kind of put it in your guys' hands, but we wanted to come with some kind of recommendation. It's just kind of something that we came up with in a discussion prior to the commission meeting.
Anything along, I doubt anything along these lines, but anything comparable situations that have ever occurred that we've looked at?
Not that I've been experienced of. Anna, you've been here longer.
So, nothing comparable to this exact situation. However, I will say, with seriousness, the reason that the recommendation was made is because this is a violation of an individual's privacy, and we do allow individuals into person's homes, and we don't want individuals to take that task lightly. And that is why the recommendation was made as it is. And so typically if something has been done, we have for example at the real estate commission, we had an individual that while they were showing a home, they went into an individual's medicine cabinet and used like Excedrin. And the recommendation for that was a suspension as well. So we've had, whenever we've had an individual essentially use the property for detention that they weren't there for, the recommendation has been a more severe recommendation. So it may have not been necessarily in this board, but I would say that the Real Estate Commission is more analogous in this, and so we've made similar recommendations.
So I guess the difference too that I want to point out there is they're upheld to a code of conduct, where USPAP doesn't have something similar.
But the commission, for that particular reason, they don't have the code of conduct that they have. It is not in their rules or statutes. So their rules or statutes does not include professionalism.
And I'll second off that. Something I think was a very important part of this is that it happened while they were conducting an appraisal, and so I think that they were in the complainant's home for a business purpose, and this incident occurred. And so I think that is something that should be taken into consideration, and something that we had to take into consideration when making the recommendation. Come in, yes, and when you're getting an appraisal conducted, it's probably for something that's going on in your life, that you're trying to sell your house, something like that, and so it's they want you to come in. You're there to help them, and so.
Yeah, this is a serious allegation and a serious recommendation as well. So I think that we need to consider that. That's and I'm just speaking out loud here. And my personal opinion is that it kind of feels like it's outside of what our area. And like I don't have the expertise to recommend anything other than what legal counsel is recommending. This isn't like a specific violation, and so for me it comes down to either accepting that or not, and others may feel different, but that's just my opinion. Is there any, again, just speaking out loud, I mean, what about transferring this over to the legal channel and seeing it, and if they found that there was criminal activity, then that's a specific violation of USPAP that we can address.
Agreed citation, they could voluntarily enter into that. And they would, of course, be afforded due process should they refuse to do so, which would, could be a formal hearing or being represented. And of course, Taylor, correct me if I'm wrong, but what I'm saying is that, you can move forward with the recommendation based on the evidence before you, and the fact that the video and then his confession as well sort of, that's why we didn't wait on sort of, a conviction at this point. We felt like and the range is, even in our private discussions, we were kind of all over the place at first, but then with some of the other boards, borrowing from them, but also realizing that it is a crime, and so that's at that point, it got real clear for us then at that point.
You do have the power to refer this to law enforcement. That's something that I've done in other commissions, other boards. That's what you want to do. In this particular situation, why I did not make that as a recommendation is because it's kind of I think in this situation, this would be the complainant's choice whether or not they want to do it, because it was kind of their personal boundaries that were violated. So that's why I didn't link to that. But you do have the power to recommend it to law enforcement if that's something that you would prefer to do.
I have a couple of questions. Number one, if we do agree to this recommendation and the respondent agrees as well, it will become a public will become public knowledge. It will be posted on the website under the respondent's personal name. Is that correct?
Correct.
What will be said there? What will be identified as their?
It'll be what the violation is, the statutory violation.
Okay.
But I will state the complaint is a public record right now.
Already?
Yes.
Okay.
Any complaint that is submitted to us, any response that's submitted to us is a public record, which we'll discuss here in a second.
Is the name public?
Yes.
Okay.
Right now.
Yes, it's public right now.
Someone could request the information.
Okay.
So what is the statutory violation?
Yeah, that's what.
While they're looking that up, was there anything discussed or brought up? I know it's such an unusual and serious offense. Was there anything brought up at the conference relative to privacy or public trust or anything like that at the conference? I mean, I know it's such a unique situation, but was there anything at all just talking about any issues whatsoever like this?
No, there wasn't. In the past we've had some other issues, and the individual has maybe come in front of the commission and we've asked questions, but that's again, this is just something different than I've ever seen since I've been here.
Additionally, we did talk about the correct amount of time. Like we discussed 3 months, 6 months. So that's something that could also change.
I had a second question.
Yeah. Yes.
Can we offer an option, and that is either how do I word this? Either the respondent can retire his own license, or we will do this.
We could, if that's what you wanted to vote on, the option to voluntarily surrender.
But he has the option to retire his license anyway at any point. And if that, so my question there is, if he chooses to do that and not sign the consent order or whatever it is that we agreed to, then it will not be a public.
So if you were to vote on giving them the option to either voluntarily surrender or to accept the 6 month suspension, it would be within the set of a consent order.
Okay. So if he agreed to the retirement of his license, that would be published.
If he did it via consent order.
Okay.
So, like, the only thing that would not show up on our disciplinary action report is going to be a dismissal, a letter of warning, or a letter of instruction.
So my thinking on this is it is an egregious violation of public trust. That's the use pat issue for me. So I don't know. I don't want to make the motion. Somebody can make the motion.
But I just wanted to go back to, I guess you three had gotten together and looked at other commissions, and you looked at the real estate commission regarding the Excedrin. What other commissions did y'all sort of look at, and information did you mind to come up with the 6 months? I agree with Mr. Atwood. It's just a great disservice to the public trust, and I guess I just want to make sure that I'm really taking consideration the 6 months, because that's fairly significant. So I just want to make sure that I understand exactly if there's any sort of commission that y'all sort of looked at to really pull the 6 month recommendation.
So so I've been here for a while, and it was just like a conversation we were thinking about when it comes to issues of public trust and those types of matters. We're thinking of some kind of consequence when it comes to an individual's license. we're thinking suspension, we're thinking revocation. Those are the areas that we're the realms that we're in. And so we had the conversation of which type we're in. And so this was ultimately, and remember, this is just ultimately a recommendation that we provide to you. And so 6 months is what we came up with. We thought that the commission may consider. And so that's around the amount of time that we've provided, but like there wasn't necessarily, we didn't really go beyond like the real estate commission because there's really nothing that's exactly like analogous to it that would match any of our other boards and commissions. But if we had thought of something like that, it would be in the suspension or revocation category. So it is more so of our recommendations are to let you know, like, this is the category of where we think you should possibly be in. This is what our recommendation is, and you can adjust it accordingly, as always, as we provide to the commission at that point in time.
I have my concern about this is that when we're talking about 6 months or 3 months or a year, whatever, in some cases we're dealing with punishment. And my concern is after 6 months, what is keeping them from doing it again?
I agree.
And unfortunately, we're not a legal court where we could say 6 months plus counseling or whatever. Is there any continuing ed course that could be augmented along with the 6 months?
We discussed that as well, but
Yeah.
we weren't aware of any courses that would be
Right. We couldn't think of any courses.
That's what I was wondering. Is there anything we have there other than you type?
I didn't think of any courses. Also, the respondents stated they had taken an ethics course at the time, and I'm not sure exactly what if how on topic that would necessarily be. And we do not have the jurisdiction or the authority to offer someone something such as counseling.
Sure.
And of course, we can't prevent or know if someone is going to do something like this again. And so that is something that you will want to think of when you're making that decision in your recommendation.
Another thing that we were just discussing was something that could be included in the consent order is having them come before you in 6 months if you'd like them to, and kind of just speaking with them and seeing.
Can you speak a little about what the suspension would look like? Is there any sort of, continuing education or anything that they have to take while they're there, or is it just 6 months they would have their license back?
So, as written, it would be a 6-month suspension where you don't practice at the time. Your license is inactive, suspended for 6 months at the time of the signature of the consent order. For whatever 6 months would be at the 180 days. Then we can add whatever additional stipulations the commission would like to include at that time. But that is what the present recommendation is.
Does this affect him? I would assume not, going to another state and practicing. I mean, obviously it's going to be on the ASB or, the foundation. I don't know which one.
ASC.
ASC. Yep. So any sort of ramifications there besides beyond that?
So the individual would have to, this would be reported to the other jurisdictions that they're in. So they would be notified if they were to sign the consent order of what would happen. And then it would be up to the other jurisdictions to make the determination as to what happens. But it would go on the national registry and be on the registry for five years.
And the other thing is, if they applied in another state, they have to answer those questions we talked about earlier. Have you ever been convicted? Have you ever had a complaint or found guilty? I am I just kind of want to talk out loud too a little bit, but we cannot undermine or discount the gravity of this complaint at all. We're not. I don't want to ever do that. But at the same time, a 6-month suspension virtually would put most appraisers out of business for the rest of their career. And so I don't want to take that part lightly, because they'll have to disclose that for the rest of their life. So I'm just going to say that, but at the same time, I don't see any other option. I mean, I've struggled with this ever since I read it. We don't want to undermine the complaint in any shape, form, or fashion. I don't really want to put somebody out of business, but I don't know that was his choice when he made his decision to do what he did.
Again, the 6 months is just a recommendation. So if you guys feel a different time is more appropriate.
I don't think the time limit, if we said 30 days, it would still go on his record for the rest of his life.
Yeah, I just was putting out there if you don't agree with
so
the 6 months.
I don't think that, the options are take your medicine or retire your license. I mean, I think that's the only options that are there. So I'm going to make the motion that we accept council's recommendation for a 3-month suspension.
Okay, we've got a motion on the floor.
Just to clarify really quickly, sorry. Are you
Say 6 months.
Yeah,
I said 6 months.
Yeah. And additionally, are you wanting it to be an option where they have the option to retire their license in the consent order or accept the suspension, or are you just wanting it to be a motion for the suspension?
Just for the suspension.
Okay.
The respondent can make his own decision.
Did you bring up the option for them to come before this board at some point in time for reinstatement, or was that part of it? Okay.
I did not include that in my motion.
That's something that you guys can require if you would like.
But if not,
They would just be
after the 6
automatically
months, their license will be
reinstatement.
set back to active.
Yes.
Okay, we've got a motion on the floor. Further discussion? Second. Any further discussion?
What would a letter of warning do for them?
We don't consider that formal discipline within our office, but it is reported to the National Registry. Right? Yeah.
I think at this point in time, that just wouldn't be, on the same level with this type of offense, any kind of a letter of warning. I mean, I think, to Jim's point, I mean, as soon as I read this, my initial thought process was 6 months is basically, a year or 2 years or whatever. I mean, it's essentially the same thing. However, how do you weigh the severity of the public trust, which is something that is so serious? I don't know what else we do besides take legal's advice, because it is something that is, the public trust, particularly inside someone's home. That to me is kind of another step too that I think is I don't want to do it either. But I don't know what other choice we have other than to show the severity of what this kind of act in someone's home represents, the seriousness of it.
Was that a second?
That was a second.
All right. We've got a motion and a second on the floor. Any further discussion? Okay, all those in favor? Aye. Any opposed? One opposed. Okay, motion carries.
I just want to provide some further comments to Mr. Haston regard it's really because there wasn't anything necessarily analogous to what occurred. Anna did a great job explaining the philosophical position. The only thing that we could remotely compare it to is, like, for example, with home inspectors and auctioneers where I used to come from. If there was a theft inside someone's home, maybe just they reached inside the refrigerator, they're violating some barriers, then we would be looking for a suspension or something to that effect. The reason why we didn't go with the revocation right out the gate was because there was not the crime has not been reported. The victim has yet to do that. We wanted to give them the opportunity to do that and to make that decision for themselves, because then they're the witness. They're having to they're the ones that have been going to those court dates and do the rest. And so for us, suspension is where we landed, and then trying to find that range to say necessarily we're taking this serious, and so that was sort of the background there. So I wanted to give you a little bit more because I knew you were.
Yeah, no, that's great. I again, it's a massive public distrust. So I totally agree. It's just a hard.
This is a very specific incident, so it was hard to find anything that was directly on point with that. And I'll say theft in someone's home, or for the accountancy board, we had somebody that took personal documentation with them, and the board wanted to replicate their license for that. And so it's kind of, they're not things that are directly on par, but within the same ball field.
Okay. I think that concludes our legal report. We have
That's the last
one more item, I
report.
believe, the sunshine law.
Alex is going to bring that up now as we're waiting on. It should be right here to Miss Tucker will be over your shoulder and everyone else to my right. And then the driver's seat over there.
Okay. Can everyone hear me? I still hear my- Okay. All right, so every year or so, it's been a couple years though, we are required to update all of our boards and commissions on the Open Records and Public Meetings Act. And so we're going to go through some information. It's kind of long, but it's important and required. So if you have any questions at any point, please let me know. Here's the disclaimer. I'm not going to read through it. Basically, it says that the information is, I provided the information. It says accurate as it is possible. But of course, if you have any specific questions about specific instances, please reach out to me regarding any questions. And this should not be construed as particular legal advice for those particular matters. And the information should be provided as is, and a lot of other words. So this is a general disclaimer for this if you wanted to look it over. Okay, so first we're going to go over the Open Records Act. This is the citation for the Open Records Act. So first, what is included in the Open Records Act for a board or commission? So things that are include documents, papers, letters, maps. So if, for example, when we were just talking a second ago, anything that comes into our possession is considered a public record. So all of the complaints that come in, all of the responses that come in, so copies of those appraisals, all of the documents that you have before you today, those are all considered public records. All media, electronic data, and other materials and are considered public record as long as it's made and received in accordance to the law. What's not considered a public record are the devices or equipment where the records are displayed. So this computer is not the computer itself, but the documentation is considered to be a public record. So when your meeting agenda is normally given to you on the iPad, everything is on the iPad is an iPad, but is a public record, but not the iPad itself. the Public Meetings Act. So we're going to go over different areas. First, what it is, what is a meeting, what's required by the Public Meetings Act, and then what happens if the board violates the Public Meetings Act. So the General Assembly declares it to be that the policy of the state is that the formation of public policy and decisions is public business and shall not be conducted in secret. So if you saw the beginning of this presentation, it said, "You are my sunshine, the only sunshine." So that's why we call it the Sunshine Law. So everything is to be conducted in the sunshine. Basically, we want government to be open and transparent, meaning that nothing is to be done in secret. And so everything that you do is to be done here and on the record. So no decisions are made outside of the public view. So this is not to be construed to limit any of the rights and privileges that are contained in Article 1, Section 19 of the Constitution of Tennessee, which refers to the free speech clause of the Tennessee Constitution. So this is generally here is a case related to the Public Meetings Act. So the Public Meetings Act should be construed broadly to promote openness and accountability in government and to protect the public against closed-door meetings at every stage of a government body's deliberation. So we want to make sure that the public is able to see the commission and any other governmental entities make all of their decisions in public at every stage possible. So all meetings of any governing body are declared to be public meetings open to the public at all times except as provided by the Constitution of Tennessee. So there are very little exceptions to the Public Meetings Act. There is one, it's called an executive session. We'll talk about that here in a second, but all of our meetings are open and they're on the record. So that includes, as we'll see a little bit later, subcommittee meetings and committee meetings. But you are considered a governing body, which are members of the public, 2 or more members with the authority to make decisions and recommendations to a public body on a policy or administration. So this applies to all of our boards and commissions here at the Department of Commerce and Insurance. So a meeting constitutes the convening of a governing body for which a quorum is required in order to make a decision or to deliberate toward a decision on any matter. So committee and subcommittee meetings are included. This board does not really have subcommittees or committees, so every single one of our meetings are considered a public meeting. But we already knew that because we just talked about it. A meeting does not include any on-site inspection of any project or program. So when an individual submits a public records request, one of the options is to submit an option is to inspect a material. So I can either disseminate the material to the individual by mail, which I have never done, or I can submit the material to the individual through electronic means. Or they can come in and inspect the materials, which means they come in and they look at the materials. But that's not considered to be a meeting. So, what is not a meeting? A meeting does not include two chance meetings, chance meeting of 2 or more board meetings, so board members. So if if Commissioner Mansfield and Commissioner Atwood were to run into each other on the street, that is not considered a meeting. But if you guys were to decide that you were going to meet each other at Bicentennial Mall every Thursday at 10 o'clock p.m. doing who knows what, that is considered a meeting. And so the public would need to be noticed on that. So a chance meeting is considered on that. So no chance meetings or can be used to decide or deliberate public business and circumvention of the public records requests. So, at this time, discussions at not meetings should not constitute should not constitute deliberations. So, that means examining and consulting in order to form an opinion, weighing arguments for and against the proposed course of action. However, there are certain items that are not meetings, such as lunch breaks, restroom breaks, smoke breaks, and recesses in between our commission meetings. Those are times that are considered not to be meetings. For example, one of my boards, even though I don't love it, meets every evening before their board meeting to have dinner. That is not considered a meeting, as long as they're not discussing board business. So what makes a board a meeting is when you're discussing anything that is considered board business. So when we're not on the record and during breaks, we're not supposed to talk about anything related to board meetings, anything outside of this. So like even that includes email. So for example, whenever we send you guys our meeting materials, you'll see that none of you are included on the meeting materials because you're all blind copied. If you are copied on that email, it would be considered a meeting because we're discussing board business. So that's why board members are always blind copied on that information. So that is something that is important to include. Also, this is important to remember. The Public Meetings Act and Open Records Act does include electronic communications. So, if you are texting each other related to board business, your text messages, phone calls are subject to the Open Meetings Public Meetings Act. So, even if it's on a non-state related device. So your phone could be subject to a public records request. So what are we not going to do? Text each other about board business. But we weren't doing that anyway. So we're not worried about it. But that is generally the information what we're regarding. So any questions about any of that? Regular meetings and special meetings also are included to the Public Records Act. So sometimes there's a special meeting, for example, an emergency meeting. This board has not had emergency meetings. An emergency meeting may be called when there's something that cannot wait prior to a scheduled meeting. If the board is required to discuss something in an emergency meeting, it still follows all of the requisite requirements for notice and all of those particular things, but it is still noticed to the public and still available to the public. The one exception is going to be called executive session. So executive session occurs when one or more members meet with their board's attorney and the board is under threat of lawsuit or has been threatened with suit, and the members ask their attorneys related to such a suit. So that's it. That's all that occurs in an executive session. There's no further discussion about any other board business at this time. All that's occurring is the attorney is talking. So if we were to have executive session, I would be discussing anything related to pending lawsuit or threat of litigation to you all. It would be me leading that, and the only thing that you are able to do in that circumstance would be able to ask me questions related to the lawsuit. No other types of conversation occur at that time. So that's the way that executive session works. It's a questions, you're asking questions, I'm answering questions and giving you that type of information. Executive sessions are not considered public meetings, so that would not occur in one of these areas. It is not required to be noticed to the public. Those are closed doors and the public is not invited to those matters. But again, that's only under the threat of litigation. Also, we may have an executive session if there's something related to an HR related matter. But This board, likely this will not occur, as this board does not really have, you do not hire your executive director. So some of our boards hire their executive director, and that would be an example of having to have the need for an executive session. So again, during executive session, there's no deliberation about a specific matter before it, or potentially before any executive session. So nothing about board business. If there's anything related to board business or requires a vote, that will come back to the board meeting and just be discussed on the record so the public can attend. So, for example, this is an example: oral interviews that were conducted by the Civil Service Commission of the Maury County. They were individuals that are applying for jobs within the Maury County Sheriff's Department do come within the provisions of the Open Meetings Act. So, for example, one of my boards is looking for an executive director. If an executive director candidate comes before the board and the board has questions for that candidate comes before a board meeting and the board will ask that individual questions. That would not be something that would be considered for an executive session. So, example of board member emails. Here are emails that we can do and emails that we should not do. So, the chair emails. Here's a news article. That's fine. I'd like something to be included on the agenda. That's fine. But we're not saying, here's a news item about one of our licensees. We should consider revocation. That is not fine. So we are wanting to make sure that we relate all of our things related to our board business. That also here's another note too. We want to make sure that we're not doing outside research when it comes to our board meetings. One of the reasons that we do present all of our information to you all anonymously is to prevent any form of impropriety and bias. And so doing your outside research on an individual completely nullifies that. So we want to make sure if we're looking at someone that we're not saying, oh, well, I looked this person up on Google and this is what I found. So that would not be a good idea to do prior to. So any questions here? And also when we're doing communications, and you'll see here, if you're emailing the commission's counsel, if you have a question about the legal consequences of something the commission has done, that's totally fine. But you're not saying, I've taken action as a commissioner and now someone is upset. And the person that is upset is me. I am the person that's upset. So that is not something that is permissible, that we should avoid doing at all costs. So also sometimes as your job as a commissioner, your name is on the website, so people are going to reach out to you. At that point, what you should likely do in those circumstances is reach back out to Glenn or reach back out to both or me if it's related to legal something, and we'll reach out to that person. You don't want to give your opinion as a member of the board, but you can if you would like to answer questions generally as a person, because you still are real estate appraisers, or but you don't want to give your opinion as a board member. Remember, you cannot speak on behalf of the board. So, if you send an email or pick up the phone call to another commissioner, again, that's not considered a chance meeting. Even if you don't discuss board business, it does give a strong appearance of impropriety, and it should be avoided. So if one of our members cannot attend a meeting in person, so our policy is that the person can vote, but the person's presence does not count towards quorum. So if we have quorum for our board is 5 people, So if we have four people in person and one person is online, we don't have quorum. So we will need 5 people in person at all times. So, but if someone is participating in person online, all votes will need to be made roll call, so we will be able to identify which person has made what vote for the public record. So that's what I was saying before. Our department policy is that a physical in-person quorum is still required. So anyone attending by electronic means does not count toward quorum. So this is a case that says any act is construed most favorably to the public and is all-encompassing and applies to every meeting of the governing body except where the statute on its face excludes its application. So this just means if an action is taken related to a board action, it is more likely going to be considered to be a public matter. That's something that needs to be put on the record, something that is an open record. These are just another examples of, this is talking about the application of the meeting. So this was written prior to a statutory change, but I'll go ahead and say it. The public has the right to attend and observe our meetings, but not necessarily the right to participate in our meetings. But the department does permit comment so long as the comment is not disruptive. But stay tuned because possibly something may have changed. But as for now, this is just our general policy and how we've always operated. So this is just talking about the 3-prong for test for adequate notice. It must reasonably describe the purpose, sufficiently in advance of the actual meeting, and posted in a location the community must become aware of such notice. So we post the agenda for this meeting a week in advance on the website. So that satisfies the 3-prong test for actual notice for the meeting. So all meetings have to have notice, and that is not something you have to worry about because this we handle that administratively. Yep, and this is just that. Our usual practice is to publish the notice on the website. Okay. So, what is the effect of a violation of the Public Meetings Act? Nullity. So that means if we violate the Public Meetings Act in any form or fashion, anything that was done is considered null and void. So if there's a violation, any action that's been done by the board is undone. So it is considered null. So if there was a violation, you can just consider that nothing occurred in that particular action. So that's a pretty severe penalty. So that is why we want to make sure that we're adhering to the Public Meetings Act. So in a nutshell, it's to make sure that all of our business is accessible to the public. It applies to you as a member and collectively as a board. Also, one or more members convening together is considered a meeting. This includes regular, special, and emergency meetings, subcommittees, and committee meetings. The only exception is going to be executive session, and that is only really related to ongoing threat of lawsuit or litigation. And we must have adequate notice when it comes to our meetings. So, in a nutshell, if you violate the law, any violative acts are void, and cost of litigation may be assessed against the board. Okay. The last thing I want to talk about is going to be the NC Board of Dental Examiners. And this is a case that we talk about in all of your board member orientations, but for some of you, it's been a second. So we'll go over it again quickly. So if you remember the NC Board, they issued 47 cease and desist orders to non-dentists about teeth whitening. So, in the response, the FTC filed a complaint stating that they violated antitrust laws by ordering the non-dentist to stop providing whitening services. So the board argued that they had state action immunity, but the FTC ultimately prevailed at the U.S. Supreme Court. What happened at that particular action is because they stated that the board did not have active supervision by the state at that time when it interpreted the addressing the teeth whitening services, and it also stated that the actions that were taken by the board were not particularly articulated by the board in their particular action. So just because state agencies are not simply by their governmental character sovereign actors for the purposes of state immunity, it requires more than a mere facade of state involvement in light of Parker's rationale to ensure the state accepts political accountability for anti-competitive conduct they permit and control. So, what is active state supervision? So it doesn't have to include like day-to-day supervision. That doesn't mean that we're watching everything at all times. It means that we need to make sure that we're realistically providing some kind of oversight into the board's actions and that we're promoting state policy rather than the party's individual interests. So sometimes when we're having conversations, we want to make sure that we're refraining from anti-competitive practices. And as members of the industry, you don't want to exclude other individuals from entering the market. And so if there is a situation in which I feel like we're deterring into a specific area, I might guide the board back into another general direction. But in light of that, what happened was we enacted TCA 4-4-1265 in 2021, which establishes supervising officials. So we created a position, it's a policy director. Our policy director reviews all of our board meetings to make sure that the actions that occur at our board meetings are not considered to be anti-competitive or run afoul to NC Dental. So not only is your program attorney monitoring to make sure that happens, but we have another layer of protection. Also, if an action were to occur, there are other layers of protection that occur also. The board is able to convene an emergency meeting. In an emergency meeting, the board has the opportunity to overturn the issue that has been deemed as anti-competitive. But also, there is a third scenario in which the commissioner of the department has the ability to veto any decision that the board has made that is considered to be in violation of the statute. So this is just another role of the supervising official, which states here. So this is just this is like the clear, the words are escaping me. This is exactly what is required of if something were to occur that is considered to be in violation of incidental. So it tells you the exact parameters that are outlined by the statute. So 10 business days of notice, evidentiary record regarding review, and then approve the action, remand, or veto. So it's the conclusion of my presentation. That is my contact information and direct dial if you have any other questions related to the Public Meetings Act, open records, or NC Dental. Other than that, any questions? Okay, thank you very much.
All right, thank you, Anna, for that. A lot of good information. Believe we're ready for new business.
That's correct. The fall 2023 Aero Conference, and I sent you guys the link to that along with the location and the rest. But October 6th through 8th, and that's going to be in Salt Lake City this year. So I don't know what what we've done before in the past is just select a couple candidates with a couple alternates, and because some folks they're kind of fuzzy on their schedules, or that's obviously can change in the next couple months or so. But Salt Lake City is where we're going.
Does anybody know that they have an interest in going or cannot go?
I'd be willing to go. I don't know my exact. Yeah, definitely need to check my schedule, but I'd be willing to go.
Yeah, I don't think definitely check the schedule. Just saying that you'd be willing to go doesn't mean that you're in.
So we've got one primary right now would be Mr. Haston. Do we have perhaps one more that can join him, and then we can have a couple alternates?
I'm sorry. I might be able to go.
I might be able to go.
So I will say we have 3 primaries, and if you just get back with me with your schedules, and I think out of those 3 we should. I would say we'd have 2 that'd be ready to go, and I'll just communicate directly with me, and then I'll keep you abreast of the situation as well. And then all we'll need now is a motion in that regard. So we'll say we'll approve 3 of our members, and then once they're back from me, we'll firm that up, and then I'll send you the registration and all the rest.
Okay, we've got a motion on the floor.
Second.
Motion and a second. Discussion. All those in favor?
Aye.
Any opposed? Okay, our motion carries. Any other new business? I would like to say on record, if Commissioner Atwood, this may be his last meeting, and he's been here a minute, and is somebody when I joined the commission, I looked up to, and he has been an asset to our commission, and so anybody who takes his place will have big shoes to fill. But just wanted to personally thank him for his service on the record. So, all right. Any other new business? Just need a motion to dismiss.
Motion to dismiss.
Second.
Second.
All right. Motion and a second. All those in favor?
Aye.
Aye.
Opposed?